As I have said many times, it's outrageous that the United States Department of Justice sued the people of Arizona to stop Senate Bill 1070. Our message for the federal government is very simple. Use federal resources to combat the cartels and who are breaking the federal law. Don't attack Arizona, which is helping to enforce the federal law. Well, Arizona is very grateful for the additional federal resources to secure the border after I signed Senate Bill 1070. Doing better is just not good enough. As the recent death of Border Patrol agent Brian Terry reminds us, our border remains a dangerous place. Our border and immigration system are still broken. Now that the United States District Court has ruled on our motion to dismiss, the state of Arizona has a window of opportunity to file a counterclaim against the federal government. Because the federal government has failed to protect the citizens of Arizona, I am left with no other choice. So today, I am announcing that the state of Arizona is filing a counterclaim against the federal government for failing to uphold its constitutional and statutory obligations. Arizona did not ask for this fight with the federal government to secure our border and to enforce our immigration laws. We did not want this fight. We did not start this fight. But now that we are in it, Arizona will not rest until our border is secured and federal immigration laws are enforced. And we will most likely have to pursue our claims all the way to the United States Supreme Court. The state of Arizona will sue the federal government on 5 separate counts. Failure to gain operational control of the border as required under the Secure Fence Act of 2006. Failure to enforce immigration laws enacted by Congress. Failure to protect Arizona from harms associated with rampant illegal immigration as required by the United States Constitution. Failure to reimburse Arizona for over $763 million in cost incurred for the incarceration of criminal aliens, and violating Arizona's 10th Amendment right to protect the health, safety, and welfare of all its citizens. Now, this fight will not be easy, and it will not be cheap. That's why I have established Arizona's Border Security Fund at www.keepazsafe.com. And I particularly want to take this opportunity once again to thank the thousands of Americans in every state for contributing to this fund to help Arizona in this fight against the federal government. I'm proud to say that no state taxpayer money has been spent in this defense. Your contributions speak volumes about the overwhelming support nationally of Arizona and its efforts to protect the public safety, health, and welfare of its citizens. You'll never know how much your support has meant to me amidst all the personal attacks that have lifted me up during this very difficult struggle. Your personal notes, your artwork, your letters, support, and most importantly, your prayers, I hold close to my heart, and I thank you. Now, if you know only one thing about Jan Brewer, you know that I'm not a quitter. Arizona is doing its duty. America, we will not let you down. With me today is Attorney General Tom Horne, whom I've invited to join my legal team in defense of Senate Bill 1070 shortly after his election as Attorney General. And I commend Attorney General Horne for his willingness to help defend Arizona in this lawsuit and for taking the lead on the filing of this counterclaim. I would now like to invite Attorney General Horn to make a few remarks. Thank you.
Thank you, Governor. Our counterclaim against the federal government for not enforcing immigration law is being filed as we speak with the federal court. It'll be available on our website, azag.gov, and at the end we will be distributing a summary of it. As the governor mentioned, there are 5 counts. I'm going to tell you about each of those counts. Count 1 is failure to achieve and maintain operational control over the Arizona-Mexico border. The Secure Fence Act of 2006 and the Appropriations Act of 2008 required the Department of Homeland Security to achieve and maintain operational control for the Arizona-Mexico border. The Secure Fence Act of 2006 defines operational control as the prevention of all unlawful entries into the United States, including entries by terrorists, other unlawful aliens, instruments of terrorism, narcotics, and other contraband. The Appropriations Act of 2008 required the construction of at least 700 miles of reinforced fencing and installation of additional physical barriers, roads, lighting, cameras, and sensors to gain operational control over the southwest border. The Appropriations Act of 2010 required creation of a plan for a program to establish and maintain a security barrier along the barriers of the United States, with fencing and vehicle barriers where practicable, and other forms of tactical infrastructure and technology. The Secretary of the Department of Homeland Security has not taken all necessary and appropriate actions to achieve and maintain operational control of the southwest border as required by the Secure Fence Act and the Appropriations Act of 2008. The Secretary has not built at least 700 miles of fencing along the border as required. The Secretary has targeted construction of less than 700 miles of fence. The Secretary has failed to provide for the installation of additional physical barriers, roads, lighting, cameras, and sensors to achieve and maintain operational control. Count 1 seeks a declaration that the Department of Homeland Security and the Secretary have failed to take all actions necessary and appropriate to achieve and maintain operational control, that they are in violation of the Secure Fence Act of 2006 and the Appropriations Act of 2008, and it also seeks injunctive, declaratory, and mandamus relief. Count 2 is a failure to protect Arizona as the United States Constitution requires. The United States Constitution, Article 4, Section 4, requires the United States to protect Arizona against invasion. The word invasion does not necessarily mean invasion of one country by another country, but can mean large numbers of illegal immigrants from various countries. The constitutional obligation to protect Arizona from this type of invasion is further clarified in the congressional requirement that the federal government acquire operational control over the border, and the statutory requirement that the Secretary shall have the power and duty to control and guard the boundaries and borders of the United States against illegal entry of aliens. Arizona is unable to bear the staggering cost of protecting itself, and even if it could, the federal government has argued that Arizona is preempted from taking action to assist in the enforcement of federal immigration law. A similar claim was rejected 14 years ago by the Ninth Circuit. Conditions have changed since then in 4 ways. First, the scope of the problem. Second, the percentage of illegal aliens with criminal records. Third, the national security aspect of the problem is illustrated by 9/11. Fourth, the statutory provisions that I've spoken about that have occurred in the last 14 years. We will be asking for a second look from the Ninth Circuit or a first look from the United States Supreme Court. This count also seeks injunctive, declaratory, and mandamus relief. Count 3, failure to enforce immigration laws. Paragraph 8 of the United States Code Section 1373 requires that ICE respond to any lawful inquiry from any state or local government regarding citizenship or immigration status. The executive branch has declared, including declarations made in this very lawsuit, that it is determined to ignore the terms and conditions of its obligations under that statute. In its efforts to prevent Arizona from making inquiries regarding an individual's immigration status, the federal government has treated Arizona differently than it has treated other states. The refusal to enforce the provisions of the federal immigration law has threatened national security and imposed a tremendous burden on the states, in particular on Arizona. Counter-defendants are not authorized to enforce only those immigration laws that they agree with. Therefore, they are committing an abuse of discretion by not enforcing these laws. Count 3 seeks a declaration that the Secretary and the Attorney General have abused their discretion by adopting priorities that are contradictory to express statutory mandates. Count 4, declaratory relief regarding reimbursement obligations. Congress established the State Criminal Alien Assistance Program to compensate states for the substantial economic burdens they have suffered as a result of the federal government's failure to incarcerate or deport criminal aliens. This statute is known as SCAP. SCAP provides that upon written request by the governor, the Attorney General shall either pay the cost of incarcerating the illegal aliens or shall incarcerate them himself. SCAP also states that the compensation to the state shall be the average cost of incarcerating prisoners. For 2009, the last reported year, the amount allocated to Arizona was $9.7 million, or 1/14 the amount Arizona actually spent, which is $135 million. Count 4 seeks, among other things, the requirement that the federal government compensate Arizona. Finally, Count 5 under the 10th Amendment. The 10th Amendment provides that the powers not delegated to the United States by the Constitution are reserved to the states respectively or to the people. While control of the border is a federal responsibility, illegal aliens who successfully cross the border and commit crimes in Arizona become a state responsibility. By not doing its job and using its alleged preemption rights to stop Arizona from performing its law enforcement obligations, the United States is violating Arizona's 10th Amendment rights. Count 5 also seeks an injunction. I'm happy to take any questions. Thank you all very much. Yes, actually there have been a number of cases. I'm sorry?
You want to talk in the microphone?
Oh, yes, there have been a number of cases along this line, and we hope this one will be successful. Yes, there's one with the name of California, and the statute that I mentioned was filed 14 years ago. That one was not successful. We're hoping this one will be.
So, Tom, is this a separate lawsuit, or is this a claim that's going to be in the federal?
This is a counterclaim in this very lawsuit. They sue us. We file a counterclaim where we're suing them.
And you guys are going to pay for this through the legal defense fund that's been set up already?
This is a joint effort by my office and Snell and Wilmer, the law firm. The Snell and Wilmer law firm is funded by the privately raised funds that the governor mentioned. On my office, Michael Tryon and myself are working on it. Michael is senior counsel, has a lot of cases. He would be there anyway. I'm elected. I would be there anyway, so there's no additional cost.